Welcome to the March session of the Forum of the Center of Transnational Litigation, Arbitration and Commercial Law, entitled Public Purpose in International Law, Rethinking Regulatory Sovereignty in the Global Area. As you know, we will present tonight the book just published by Cambridge University Press, co-authored by Mr. Pedro Martinez-Fraga and Ryan Reetz, with the same title. Unfortunately, one of the authors cannot be with us. Pedro Martinez-Fraga is really so sick and cannot or was not able to make the trip here. It is with great pleasure that I'm able to announce that Professors Jack Coe and Professor Harold Hongju Coe will comment on the aforementioned book, and that the co-author who is present, actually, Mr. Ryan Reetz, will respond to those comments. There is no need for me to introduce the speakers. You have all received, with the invitation, a note, but allow me to say that Jack Coe is a faculty director of Pepperdine's LLM in International Commercial Arbitration. He's an associate reporter on the Restatement Third on International Commercial Arbitration and a fellow of the American Bar Foundation. He is a member of the ICDR panel and has arbitrated both institutional and ad hoc proceedings under various rules. He is also, of course, and that is his fame to claim, a former scholar in residence at New York University's Center for Transnational Litigation and Commercial Law. The rest is really irrelevant. Now, Professor Harold Hongju Coe is Sterling Professor of International Law at Yale. He served as a dean there for 5 years and is formerly legal advisor to the US Department of State, but was yet unable to be a scholar in residence at our center. He is, to make up for it, he accepted an invitation to be a visiting professor at our school, but he still has some work to do. He has, as you know, of course, many more reasons to be known. He's the author of Transnational Litigation in US Courts and the co-author of Transnational Business Problems with several colleagues, and Transnational Legal Problems with some other colleagues. He received the Wolfgang Friedman Award from Columbia Law School and the Louis Sohn Award from the American Bar Association for his lifetime achievements in international law. And Ryan Reetz is the co-founder and office managing partner of the Miami, Florida office of Brian Cave, where he represents clients as trial counsel in international and domestic commercial and regulatory disputes. His practice also includes class actions, complex litigation, and regulatory matters. In addition to acting as counsel, he has served as an arbitrator in international commercial disputes. He teaches transnational civil litigation and arbitration as an adjunct professor at Emory University School of Law and taught the same subject over many years at University of Miami School of Law. He also serves as a visiting professor at the University of Navarra School of Law in Pamplona, Spain. That said, let's get to the topic. The event is an event around the book, the introduction of which I want to at least mention. Economic globalization and non-territorially based understandings of sovereignty have underscored a need to revisit, apparently, or just simply visit the role of the public purpose doctrine in customary and conventional international law. The tension between a state's legitimate right to regulate and its equally genuine and binding obligations concerning foreign investment, and here I look at somebody who will hopefully comment on this later, often rests on the scope and application of this doctrine. Unlike the orthodox territorially grounded principle of sovereignty, the public purpose doctrine has commanded little attention from jurists and scholars so far. The book wants to fill a gap and allow us to discuss it. The idea is to allow for comments first. Professor Jack Coe will go first, then Professor Harold Hongju Coe will go second, and then we give the floor to one of the co-authors, Mr. Ryan Reetz. Please, Jack.
By the way, Harold, Mom wants you to call. Thank you all for coming tonight. The book, Public Purpose in International Law, Rethinking Regulatory Sovereignty in the Global Era, is a distinctive, rich, and thought-provoking examination of the purposes for which a state may, under international law, regulate or expropriate property. The book certainly has made me consider a lot of things that I had not really thought about in a while or ever. Its method was to first explore the purpose's doctrinal origins in classical Greece, and then to examine how states in the modern interdependent world in its many competing imperatives have for themselves carved out regulatory space, albeit not in any uniform way. So one theme that one finds throughout the work is that not all purported uses of sovereign power under the banner of public purpose are equal in legitimacy, and relatedly, that gone are the days when legitimate sovereign prerogatives were whatever the sovereign said they were, as long as they regarded activities within the territory of that sovereign. In search of objective standards and common ground, in one chapter, the book offers a thoughtful account of what one can ascertain about public purpose from customary international law, but then the work, as Franco says, takes a look at the regulatory imperatives to be found in treaty texts, both bilateral and multilateral. I personally tended to gravitate toward the discussion of NAFTA and of BITs because of my background. So to my knowledge, this book is really a first of its kind and caused me to think about the challenges that the authors must have faced, and indeed those same challenges are probably the ones that caused them to write the book in the first place. And my personal approach was to orient the topic by thinking about public purpose in relation to the context most familiar to me, which is expropriation. Indeed, in my experience, the term public purpose is used primarily in that connection, which is why I like the subtitle a little better than the main title. Rethinking Regulatory Sovereignty tells me that the book is about much more than just expropriation. But focusing for the moment on expropriation, that is the taking of an alien's property, it is often stated that a taking is not lawful under international law unless done inter alia for a public purpose. One finds that rule in countless BITs and in similar texts where it is set forth as a required element, but not sufficient alone to render the taking lawful. As an aside, my students often come to the understanding that if regulation is for a public purpose, then compensation need not be paid, because they intuitively reinterpret the elements to form some sort of regulatory taking doctrine that makes sense to them. I'll come back to that. No doubt sometimes related, the requirements of expropriation law and the extent to which regulatory imperatives can exempt outright a state from the obligation to pay, I think are analytically distinct questions, or at least they often are. So putting aside for the moment whether takings of property through regulation can ever be undertaken without giving rise to a duty to make compensation, let's think instead about the routine expropriation claim. So putting on my arbitrator lawyer hat, the hard-fought question before the tribunal will almost always be whether the taking indeed happened, because most often some form of indirect taking is alleged. So what is called for is an examination of the permanency and the substantiality of the effects of the government action. For both sides, closely related will be the valuation question. Arguments, for example, about whether the property taken was a going concern so as to warrant the DCF method of valuation. If public purpose arises at all in the conversation, it's because the claimant wants a step up in compensation on the theory that a taking done illegally by reason of not being for a public purpose might entitle it to a higher level of compensation under a case called Chorzo Factory. The subordinate status of public purpose in the routine case has been underscored by the work of the American Law Institute. The Restatement Second of Foreign Relations, finished in about 1965, devotes its Section 185 to taking of property and posits that a taking is wrongful if inter alia it is not for a public purpose. So far, so good. Comment B to the section, however, says, quote, although the requirement that a taking of an alien's property be for a public purpose is frequently mentioned in international adjudications and in the works of text writers, there is little authority in international law establishing any criteria by which a state's own determination of public purpose can be questioned. There appear to be few, if any, cases in which a taking has been held unlawful under international law on the sole and specific ground that it was not for a public purpose. Nevertheless, the criterion has been retained in the wording of this section in view of its wide recognition, end quote. So, 2 decades later, the ALI returns to it in the Restatement Third of Foreign Relations, and it would again keep in the black letter the notion that public purpose is a requirement for a lawful taking, but in similar fashion, in a comment, would explain, quote, the requirement that a taking be for a public purpose is reiterated in most formulations of the rules of international law on expropriation of foreign property. That limitation, however, has not figured prominently in international claims practice, perhaps because the concept of public purpose is broad and not subject to effective re-examination by other states. One of the themes of the book is the extent to which public purpose ought to be self-defining. And perhaps to a great extent it's been allowed to be. By the time the Restatement Third uttered that comment, friendship, commerce, and navigation treaties and BITs had begun to include the public purpose requirement, although that was before there had been dozens and dozens of awards under BITs examining the BIT expropriation elements that would have included public purpose. So, at bottom, the restatements support what the author suggests. Even in the narrow context of the law of expropriation, where public purpose is oft mentioned, one finds this paradox. Yes, there is a public purpose requirement, but it performs little function because the concept is so broad as to allow most government activity to qualify. Correspondingly, the agreed upon not for a public purpose scenarios tend to be limited to the case where the foreign ruler takes property outright for a private use, or where the government decides it's going to take private property from one private owner and just give it to another private owner. Those are agreed upon as not for a public purpose. So, consistent with the foregoing and trying to establish a uniform meaning to the notion of public purpose, the book finds largely unhelpful both custom and international adjudications. The above-mentioned question of regulatory taking, I think, helps illustrate this. This is the question of to what extent can a government be exempt completely from the duty to make compensation based on the fact that it is acting to pursue, for example, a health and safety imperative of some kind. So, let me put aside for the moment the analytically separate question of necessity, that is the customary doctrine that might give rise to a complete defense under customary international law, and the related question of essential security that might be found under a BIT, and just focus on, as a definitional matter, whether authentic safety and environmental regulations are simply exempt from expropriation analysis. Right, this is the standard Methanex case, groundwater, regulating gas additives to protect groundwater. So, sample number 1. Consider what the tribunal wrote in Santa Elena versus Costa Rica, an award issued in 2000. Quote, in approaching the question of compensation for the Santa Elena property, the tribunal has borne in mind the following considerations. International law permits the government of Costa Rica to expropriate foreign-owned property within its territory for a public purpose and against the prompt payment of adequate and effective compensation. This is not in dispute between the parties. It continues. While the expropriation or taking for environmental reasons may be classified as a taking for a public purpose and thus may be legitimate, the fact that the property was taken for this reason does not affect either the nature or the measure of compensation to be paid for the taking. That is, the purpose of protecting the environment for which the property was taken does not alter the legal character of the taking for which adequate compensation must be paid, and the international source of the obligation to protect the environment makes no difference. and they dropped to this a footnote saying, for this reason, the tribunal does not analyze the detailed evidence submitted regarding what respondent referred to as its international obligation to preserve the unique ecological site that is the Santa Elena property. Now, as if they thought they had been too subtle, they continued. They continued. Expropriatory environmental measures, no matter how laudable and beneficial to society as a whole, are in this respect similar to any other expropriatory measures that a state may take in order to implement its policies. Where property is expropriated, even for environmental purposes, whether domestic or international, the state's obligation to pay compensation remains, end quote. By contrast, 5 years later, different tribunal in the Methanex case. Quote, as a matter of general international law, a non-discriminatory regulation for a public purpose, which is enacted in accordance with due process and which affects inter alios, a foreign investor or investment, is not deemed expropriatory and compensable unless specific commitments had been given by the regulating government to the then putative foreign investor contemplating the investment. That is, commitments that the government would refrain from such regulation. So, at least in the hands of different tribunal, as the book asserts, custom has not been interpreted with enough uniformity to delineate clearly the regulatory space available to sovereigns. In the book, the latter award, the Methanex award, is juxtaposed by the authors against the Metalclad case, a case involving a hazardous waste landfill that was built but not allowed to operate in Mexico. The authors in the end conclude that neither Metalclad nor Methanex offers the right analytical tools for assessing the public purposes involved in those cases. I think the two awards also prove another point that the book makes, which is tribunals are to some extent restrained by what counsel gives them to work with. And the composition of the tribunal also obviously matters a great deal. The Metalclad tribunal was chaired by Sir Eli Lauderpack, who was also one of the three arbitrators that produced the above-quoted Santa Elena award decided earlier the same year. That case involved, in part, a post-investment state law enacted ostensibly to protect endangered cacti. Certainly as counsel for Metalclad, our main concern with the cactus law was to allow our claim to be amended so we could include it as it was enacted after the arbitration had already been launched, and so we wanted to include it as a separate theory of recovery. We, of course, had no intention of making the case turn on whether in the abstract environmental regulation should be exempt. But we didn't ignore it either. We relied, for example, on the two awards in the pyramids cases. In those two awards, one an ICC award, one an ICSID award, the fact that the government was reacting to the genuine discovery of antiquities near the pyramids was not in dispute. And still, under both awards, compensation was due to the investor whose resort complex project had been brought to a halt. If I might digress, Ryan, just a little bit, in your book, you rightly note that the tribunal seemed impressed by the Bailoon Award, and I got a sort of a kick out of that. And you found it to be distinguishable and not particularly helpful in helping us understand public purpose. Our answer, as I mentioned, to the cactus law, as we came to call it, was the pyramids cases. Bailoon was more of a general purpose authority, and it actually didn't even appear in the written pleadings of the parties. Rather, we relied on some old chestnuts like the de Sable case, I don't know if you recall that, or a wonderful case called the Tatler, and also some Iran U.S. Claims Tribunal cases. The latter awards in particular we liked because they didn't emphasize fault, or they de-emphasized fault as an element in responsibility, and also, to be honest, represented what there was to deal with in the late 1990s, remembering that there wasn't yet this launch of so many dozens of BIT cases. So that was the most recent authority we had to do with, rather a dramatic comparison of what we have to today when we're swimming in all of these awards. Mexico obviously relied heavily on the Elsie case, which involved a requisitioning of a factory in Italy, which turned out not to be compensable. So the balloon award was introduced for the first time by me in the close because I had found it 2 nights before in the Georgetown Library about midnight, and not because we were sandbagging. And when I mentioned it, all 3 arbitrators started writing. So I thought, okay. But you're certainly correct that it's not a perfect fit, and it certainly doesn't have a lot to say about the nuanced policies of public purpose, but we were certainly glad to find it. It also didn't hurt that we thought at least 2 of the 3 arbitrators in the balloon case, Judge Schwabel and Don Wallace, were known to the tribunal that we were dealing with. So returning to this excellent book, it also deals extensively with the various demarcations of regulatory space to be found in treaties. And in digesting the material and trying to think about it in a simplified way, and in focusing in particular on investment treaties in particular, I wondered whether one might classify the references to regulatory space according to the extent to which they affect responsibility, that is, or more precisely, the degree to which they affect the possibility of compensation, thinking about it like a lawyer at the moment. You'll all have been aware that under BITs, investors, aggrieved investors, can bring these direct arbitral claims, so this is the context in which this arises. So in looking at the elements of treaty architecture that you deal with in the book, at one end of the continuum in my taxonomy is the simple expedient of reserving full stop regulatory space, that is to expressly carve out a particular activity area or to preclude it outright from foreign ownership or involvement, and therefore not being covered by the protections extended under the treaty. And if one examines the copious reservations to the NAFTA, one sees quite a surgical use of these kinds of reservations. At the other end of the continuum are much softer claims to regulatory space, and the book looks at these too. There are, for example, the diffuse references that one finds in the preambles of treaties, such as those that mention sustainable development, or in the case of U.S. model BITs, a stated desire to achieve the BIT's objectives, quote, in a manner consistent with the protection of health, safety, and the environment, and the promotion of internationally recognized labor rights, end quote. So under standard rules of treaty interpretation, obviously preambular material can have a bearing on how one interprets the treaty and how the tribunal thinks about a particular issue, but not in any real predictable way, I would submit. This is for various reasons, in part because these preambular mentions often are juxtaposed side by side with competing imperatives that one might argue, given the lack of a hierarchy, cancel each other out. In any event, the more specific provisions setting out the protections of the BIT and perhaps the definitions and any interpretive annexes that you find will often be what controls and very infrequently the preamble language. A second category, again on the soft end of the continuum, I would submit, are claims to regulatory space that talk about very important regulatory objectives, but upon close inspection are largely precatory. And here I have in mind NAFTA Article 1114. Under the heading Environmental Measures, it says, nothing in this chapter shall be construed to prevent a party, big P, from adopting, maintaining, or enforcing any measure otherwise consistent with this chapter that it considers appropriate to ensure that investment activity in its territory is undertaken in a manner sensitive to environmental concerns, end quote. The otherwise consistent with this agreement proviso is found in many provisions that the book analyzes, and it means that if regulation in question is, for example, not fair and equitable under Article 1105, or constitutes a taking under 1110, that compensation must be paid per the normal operation of the treaty, even though ostensibly the regulation was to meet an important environmental objective. At least that's my interpretation. Perhaps we'll have a nice argument about this. A third category of provision bearing on regulatory space is less soft, I would say, and actually curtails host state exposure, I think, perhaps significantly, without carving out completely a given area. And here I have in mind the guidance found in recent U.S. model BITs in connection with expropriation, which provisions are expressly made subject to an annex. And that annex says, and here we're talking about the usual case of allegations of indirect taking, in pertinent part, and a number of you will know this annex, quote, except in rare circumstances, non-discriminatory regulatory actions by a party that are designed and applied to protect legitimate public welfare objectives, such as public health, safety, and the environment, do not constitute indirect expropriation, end quote. This guidance doesn't preclude outright recovering for an indirect taking claim, but it certainly reorients the claimant to focus its proofs on the qualifiers. Was the measure discriminatory? Was it designed to protect legitimate objectives? Was it applied to protect these? And then the sort of mysterious language, except in rare circumstances, that leaves a lot to the imagination. So here I finally mention a similar textual device that caught the author's attention, which is a proviso that comes up once in a while, and this was in connection with the financial regulation. Host state given rather wide latitude as long as the measure is reasonable and undertaken for prudential reasons. And as you suggest in the book, this introduces a nice element of objectivity, or at least suggests the idea of an objective standard. So there's much in this book to admire. Spoiler alert, the authors contend that the public purpose doctrine is important, deserves to be given meaningful content, but at the moment is substantively bankrupt, I think is the phrase I remember. So to close, let me pose some questions that the book conjured up for me. First, when we talk about public purpose, are we talking about a legal conclusion that fully excuses a state from any responsibility provided other elements are met, or are we talking about a characterization that bears only on compensation? Perhaps there are levels of public purpose, some fully excuse and some merely diminish liability. In either case, one can only agree with the authors that objective standards and methodologies would be an improvement. Second, do we dare establish a hierarchy of purpose or objectives? Are protection of antiquities, as in the pyramids case, protection of groundwater, as in Methanex, protection of cacti, as in Metalclad, of equal rank? Where does protecting consumers from mad cows fit in? From Ebola, from a raging fire, from imminent floods? And how does all this interrelate to the customary necessity doctrines and similar defenses available to a state? Third, does anything change in terms of hierarchy and the impact of the regulation if it's embodied in a criminal statute? Fourth, to what extent must a state in its measures base those measures on solid assessments of the weight and probability of the risk being addressed? That is, how risk averse is a state entitled to be, and how carefully must they act to weed out junk science before acting to denature the investor's project in the name of public purpose? My students have a lot more questions than these, and I have fewer answers than they have questions, but I can tell you that this book will help me answer more than usual. In the end, the authors offer 11 non-exhaustive propositions about how public purpose might be rehabilitated, to use their words, and perhaps we can talk about those if I will just relinquish the microphone. Thank you.
You would have to switch off your microphone. Thanks.
Thank you. It's a pleasure to be here, and thank you to Ryan for the book that he has done with Pedro, which is a impressive achievement. And then also thanks to my long-lost brother, Jack Coe. His presence here allows me to explain two great mysteries, which I often have to explain. First, why do I use the name Harold Hongju Coe rather than just Harold Coe? And what does Hongju mean? When I was a law student, my name was Harold Coe, and then it turned out there was a guy named Harold Coe, C-O-E, an anthropologist who spelled his name like Jack. And my father solved the riddle by saying, why don't you call yourself Harold Hongju Coe? You will be the Korean one. And then people will know that there's a difference between you and the other Harold Coe, and that's what I started to do, which is why everything I've published is under the name Harold Hongju Coe. On the second question, which is what does Hongju mean, it means Jack's not my brother. And I reveal that now. Coe is my God pilot, as we say. This is a very impressive book that asks the right question and offers a thoughtful three-part answer. I think it's just the right question, namely, how do you adapt the public purpose doctrine for the age of globalization and interdependence? And the three-part answer goes to history, diagnosis, and prescription. And I give 2.5 cheers for that. I think the history is extremely well done. The diagnosis is thoughtful and I think correct, although quite condemnatory in its conclusion. And the prescription, I think, is a valiant effort, but doesn't actually get us there. And I think the net result will be that the answers will be fleshed out in litigation and arbitration, sparked by the fact that people now have a book that they can cite for both sides of that proposition. Now, the other reason why this took me back was that in 1982, 33 years ago, as a first-month associate at a large law firm working on Iranian claims, I was asked to work for 6 months on a memorial in the Amico Iran case on the standard of compensation for expropriation. It was later published under someone else's name as a large law review article in the Virginia Journal of International Law. But in reading it, I had to write a section on the public purpose doctrine as part of the standard and was struck by how little there was on this issue. And I was particularly struck by the fact that the Sabatino case, which was sort of a wellspring of understanding, had been a case which had shockingly upheld a taking by Fidel Castro that would have been struck down if it had been done by Bill de Blasio or Andrew Cuomo under the Fifth Amendment. And so the question was exactly what did the public purpose doctrine mean? So Pedro and Ryan give a three-part answer. They start with history, and I think this history is really remarkable. They start with the historical roots of the public purpose doctrine in the ancient Greeks, Plato, Aristotle, and Thucydides. They develop it doctrinally with a panoramic sprint through 6 different doctrinal forests, NAFTA and conventional international law, and the debate between metal-clad and methodex, which they frame very crisply, customary international law, human rights treaties, which is an area in which many investment arbitrators do not venture, bilateral investment treaties, the principle of sovereignty over natural resources, and then finally, domestic foreign investment protection statutes. They've organized this material in a very accessible way, and I think that this is thus the definitive treatment of the history, to which I give them great credit. What about the second part, the diagnosis? I think they put it well in terms of the attempt to find some kind of normative balance between a state's obligation to engage in regulatory sovereignty versus the host state's obligation to protect foreign investment. And in examining that, their diagnosis is that this doctrine of public purpose has gone through what they call multiple permutations and iterations, but has ended up as incoherent and devoid of content, and has created enormous asymmetries between the investor and the state, the developed and developing countries, and concerns about what they call process legitimacy. The book is very well written. One colorful quote that stuck to my mind was the idea that the doctrine, quote, is being used as an aider and abettor to states that seek to renege on commitments to foreign investors after having extracted strategic value from foreign direct investment. But having put it that way, and even though they represent investors, the book is not, I think, tipped in either direction. It's a careful effort to try to understand where both investors and states are coming from. What I think they end up struggling is to find exactly what is the paradigmatic case of a violation of the public purpose requirement. And there they look to Section 712 of the restatement. I think everybody would agree that if a public official steals something and gives it to himself, or steals something and gives it to another private person, like his brother Jack Coe, that would be a violation of public purpose. But then the question is, what other kinds of use of public authority to take something and give it to private entities also fit that bill? And there I think they're correct to say that the doctrine is extremely incoherent. That leads them to a very admirable search for objectivity, or search for objective standards. I think they correctly understand that the problem is subjectivity and self-judging. And they have 11 propositions that they assert in their last chapter, which is a valiant effort to try to fix the law. A number of these jumped out at me as very important. Number 4, the idea that interdependence should be the basis, which rejects a winner-take-all approach and requires some sort of cost sharing between the investor and the state. To my mind, this is very reminiscent of Guido Calabresi and the cost of accidents, and the idea of why spreading costs between the cheapest cost avoider is a way to go. And it's put into the language here of reasonableness and proportionality, which I think is a potentially promising approach. A second thought they raise is that this should be done through multilateral negotiations between developed and developing nations, and that you can achieve objective standards that way because they're in different positions. I think that the difficulty that we're seeing around the global climate change treaties show the difficulty of this actually being done. So while I agree that that would be the best process to achieve objective standards, I doubt that we're ever going to get there. Their 6th proposition is the notion that there should be a hierarchy of public purposes. And here is where I think they're venturing into human rights law is very helpful, because I think it forces us to think about human rights law and how human rights law defines the public good. Human rights law talks about public safety, public order, public morals, and public health, but not explicitly about public purpose. And what Ryan and Pedro are suggesting is that somehow public purpose is in a hierarchy of public purposes. I think the battleground here will be on the health issue, and particularly going forward on tobacco control, and now full court press on these issues that's being undertaken by Philip Morris and British American Tobacco against Uruguay, Australia, and in the WTO. If you haven't been following it, you should watch John Oliver, his YouTube segment, 18 minutes, which is a remarkable, it's funny and also a little bit obscene, but extraordinarily well documented accounting of the various forms of litigation that are going on. I'm advised that the Campaign for Tobacco-Free Kids were the people who actually planted him with most of the information. And it's really a devastating statement about the extent to which investors, in this case tobacco companies, are asserting that health protection is an impermissible violation of their own human rights with regard to both property and rights of commercial speech. Finally, Ryan and Pedro end up trying to offer the combination of a substantive and procedural solution. The substantive solution is agreement on text in draft regional trade agreements. And again, for the reasons I said, I don't think that that's likely to happen. I don't think you're going to see it in the TTP or anywhere else. They also have a procedural idea, which is the idea of clear and convincing evidence and a rebuttable presumption enjoyed by home state investors that public purpose is not sufficient to justify encroachment on an obligation to protect foreign investment. I'm intrigued by this thought, and particularly how arbitrators would apply a clear and convincing evidence standard. And one of the questions I'd like to ask Ryan to address is exactly how this procedural test might be applied to in his view, in an effective way. I'm left at the end with a number of questions which, like Jack's, I would pose to Ryan to answer in what I know will be his presentation. The first is, what about the relationship between public purpose and the nature test applied in foreign sovereign immunities commercial activity? Lots of things can be for a public purpose, like selling buttons that hold up the pants of soldiers. But the nature is still one that a commercial actor could do. So it could be that if you focus less on purpose than on nature, you could get to a narrower test. The second is, what is the difference between public purpose and state action? You flag this issue. Obviously, a state acts, and it takes for a non-public purpose, for example, to enrich the dictator or to take from someone to give to one of the dictator's friends. But the question is, beyond that, what exactly would be state action that is done by a public actor but not for a public purpose? A third question is, how do you see the relationship between the public purpose doctrine in international expropriation law and the public purpose doctrine in Fifth Amendment takings jurisprudence? That is obviously a rich area of discussion. I don't think actually there's that much more there. I think it's treated just as summarily in constitutional jurisprudence as it's treated here. And then a final question is, what about the relationship between your reasonableness test and that of our great friend Andy Lowenfeld? In fact, at the end of the day, a lot of what you say here, Ryan, reminds me of Andy's approach to reasonableness of jurisdiction, because he says that instead of focusing simply on the concerns of a particular nation state and its sovereignty, we take interdependence as a norm. And then in resolving issues under a reasonableness or proportionality standard, we look to international system concerns. And in fact, 403 of the restatement sections E and F talk about the interests of the international legal system. Justice Blackmun picked this up in Aerospatiale in his concurring in part opinion, where he says that judges should look beyond U.S. parochial interests and the mutual interests of all nations in the smoothly functioning international legal system, and consider if there's a course that further rather than impedes the development of an ordered international system. So the interesting thing is that while you focus on Restatement 712, it might well be that the part of the third restatement that is most relevant to you is not the expropriation section, but the jurisdiction section. And what I think that leads us to is the fact that this is something which is now being fundamentally re-examined in a fourth restatement. Linda and I share concerns about where it all might be headed. But I think that some elaboration on this issue while it's under debate before the ALI, which it will be for a number of years, would be very helpful. A final point is this. Ryan and Pedro start in a very utopian way. Their opening quote is to Kant, Toward Perpetual Peace. And it's really one of those things that inspires you to do international law. You know, the notion that what happens in distant lands can create peaceful relations that becomes public law that gradually brings the human race closer to cosmopolitan constitution and perpetual peace. But it ends in a brutal reality, which you describe well. The statement that you give is that the public purpose doctrine is subjective, self-judging, based on models of dependence, conducive to all or nothing results that frustrate the expectation of both capital importing and exporting states, and defies concerns about process legitimacy. So quest for a public purpose, which begins in these noble Kantian phrases, ended up in a kind of Hobbesian, nasty, cruel, brutal, and short. I would love it if the work that you have done leads us closer to a set of Kantian rules that bring us peace. What I fear might happen is instead the book is so rich that it will stoke a new battleground where litigation and arbitration will ensue, where people find public purpose as a new battleground because your book has given them a lot of information they didn't have before. Certainly I didn't have it in 1982, and therefore we sloughed over that and went right to standard of compensation valuation and other issues. But if I were alive today working on this issue and someone brought me this book, you'd say, hey, we've got to be able to make an argument on this. So I think that this issue may not end up where you want it to be, but I give you great credit for having opened this incredibly interesting set of questions, giving us some guidance on history, diagnosis, and prescription. And I hope that as time goes on, you can continue to elaborate on this both in your scholarship and in your own dispute resolution work. Thank you.
Well, thank you to both of you for your extraordinarily gracious comments. I know Pedro's ears are burning right now, not merely from his illness, but from the very nice things that you said. Thank you also for your questions, although I'm very glad that I have left law school and am no longer subject to being graded in that sense, because they're very, very intriguing and difficult questions. Pedro and I became interested in the subject because the public purpose has sort of a vagueness along two dimensions. You could think of a horizontal and a vertical dimension in which it needs definition. And Jack touched on this a bit in his presentation. First, there's sort of the horizontal definition. What is public purpose? As we talk about in the introduction, the classical understanding of it is whatever is purportedly, according to a state's self-judging decisions and standards, for the public good, whatever is for the greater good of the polity. And in fact, in classical times, this concept, and in even more recent times, this concept of public good could be used to justify things as abhorrent and as contrary to individual rights as slavery. That's perhaps the doctrine has been softened since then, but there's still the fact that, as both speakers have mentioned, it's a self-judging standard in its classical conception. It isn't subject to any objective limits in that conception, and it really is in need of objective definition, of standards or a definition. That's the horizontal indeterminacy or vagueness of the doctrine. But there's also a vertical lack of clarity, which Jack referred to. In its most narrow sense, public purpose is this language that we see referring to expropriations in bilateral investment treaties and the restatement in classic statements of customary international law that expropriations must be for a public purpose and subject to the other criteria. There's a question, which Jack mentions, does that matter at all? The restatement seems to suggest it may not matter at all. Yes, an expropriation is not legal if it's not for a public purpose, but so what? You get compensated anyway. Another potential meaning along the horizontal scale of definition is that public purpose relates to the degree of compensation. Thinking like a lawyer, how much compensation is due if an expropriation is illegal because contrary to a public purpose, or legal because it's non-discriminatory, consistent with public purpose, and compensation is given or offered. Then there's potentially even broader meanings of public purpose, which were touched upon. One is if regulation is done for a public purpose and meets the other criteria that were mentioned, for example, in the Methanex language, is that regulation expropriatory at all? Is it tantamount to an expropriation in the language of some of the instruments? Or is it simply a regulation that does not give rise to at least expropriation liability, even though it destroys the value of someone's investment? So we looked at these issues in the hope, a hope that ended up in perhaps a Hobbesian view, that we would be able to provide greater definition and at least understand the problem a little more. And on the beautiful Kantian beginning and the nasty Bruce and short Hobbesian end, I should add, the book took a while to write, so your attitudes change a little bit over time. But in looking at this, as was mentioned, we looked at a variety of sources to try to understand in various aspects of international law, how is this idea of public purpose addressed? How is it considered? How is it expressed? How is it measured? How is it limited? And so we looked at the various areas that have been mentioned. And really, we came back to NAFTA in the beginning, not because NAFTA is focused on public purpose or even has a very clear definition. But one very interesting thing about NAFTA is it does provide a standard in Article 1101, Paragraph 4. It provides examples of public purposes that should be deemed to be public and treated that way. And it gives you a sense by providing examples of the scope of the idea. My Latin's never right, but the idea of including some items is excluding others that are beyond their general character. I know all the other people here could say that correctly. So NAFTA was very helpful. It does not provide a comprehensive solution. Obviously, it's a three-state solution which has since been reinterpreted and limited and expanded and all sorts of things. But it gave us a starting point from which we tried to arrive at the sort of principles that we've been talking about today, including the ideas of public purpose not simply being what's generally done in the public name, which I think is perhaps the difference between state action and public purpose. State action is the state acting, exercising its power. It may even be, even though it may not be a dictator taking someone's property for his or her personal use, it might be a government taking away real estate and turning it into a national park, as in Santa Elena. Or it might be a municipal government taking away someone's home for use in a shopping mall redevelopment, as has supposedly happened in some countries, like the United States. So that's state action. But our argument is that may not be public purpose. And as we hone in on the idea of public purpose, hopefully there's a better understanding of that. The other issues is we don't believe this should be a self-judging standard. There are perhaps too many self-judging standards in international investment law already, and to make a standard self-judging, especially when it's as broad an idea as public purpose, we think means to leave it devoid of content. And finally, we believe it's a standard that should have content, even if it's considered in its most narrow conception as the expropriation requirement that an expropriation be made for a public purpose. If we simply take what we call the legacy conception, the legacy public purpose doctrine at face value, well, basically it has no meaning, it has no effect, it's just kind of in there for historical reasons, we have what purports to be an international law standard that has no reason, no meaning, and no consequence. And that doesn't seem right. It seems that if the language is there, it should be given a meaning. So that was sort of our point of departure. Now to turn maybe a little bit to some of the comments that were made, skipping over the hard ones. I think, Jack, you made some excellent points about the role of the arbitrator and of counsel in developing standards in international investment law generally and for public purpose in particular. The idea that tribunals are limited by what counsel give them and by the people on the tribunals and by the facts of the case. And you also suggested, Professor Coe, that this was all going to probably end up, unfortunately, being resolved in litigation and arbitration because there's perhaps not a beautiful, objective, a priori way of coming to an understanding of this principle. And that's true, sadly, although less sadly for those of us who do this for a living. But it's true that the investor-state arbitration system is not a good vehicle for developing this doctrine. It's the vehicle that's done the most development of the doctrine, but because of the limitations that were mentioned, because it's case by case, because the decisions are non-binding, are not stare decisis, they're not stare decisis, obviously they're binding between the parties, there's no enforced continuity. That sometimes means that tribunals don't have the same concern for future decisions that judges might have in a common law system. This is not a good way for developing the doctrine better. It's one of the tools we have. It's true that it may be the only tool that is receiving general use, and that perhaps multilateral treaties are not going to be helpful in the short run because of the by definition, adverse interests of the parties that are being asked to negotiate them. But there are other instruments in the international community that may be helpful. There are, for example, the development paperwork that UNCTAD puts out on the issue of public purpose. And while we disagree with most of their approach, that's helpful. Bilateral treaties that perhaps adopt what we call special public purpose categories, or that define public purpose more specifically, can be helpful. Will they define a universal standard for international law? No, they won't. But they can be helpful because they contribute to the conversation, and as more and more of them are out there, as more and more commentary is out there, these ideas may be taken up into customary international law over time. It's a controversial subject how that happens and when you know it's happened and what exactly has happened, but that process of forming customary international law and even of forming the debate over public purpose is one that can be advanced incrementally and not merely through litigation and arbitration. Although please feel free to litigate and arbitrate these issues. So I think there is that limitation, but hopefully it's one that can be partially overcome. Jack made some excellent points about the fact that public policy is not monolithic, as we see it in the bilateral investment treaties, for example. There are different categories. There are soft mentions of public policy ideas and preambles. There are mentions that are arguably not meaningfully binding, like NAFTA Section 1114 that you mentioned. Any measure that's otherwise consistent with this chapter that does these things is not a problem. But there, we have to ask ourselves, if that's the reading to be given to 1114, have we rendered 1114 devoid of content? Or does it have some hook that can be used to create state responsibility? So it's true that we can't treat every mention of the doctrine in a treaty the same. And it's true that most of the mentions of the doctrine in a treaty or other instrument don't even use the word public purpose. But taken together, they give us a view of the state ends that are viewed as legitimizing certain types of state action, maybe at different levels. And this gets into our idea of a hierarchy of public purposes. What we call the special public purpose category, which we use as an example, NAFTA Article 1410, which allows reasonable precautionary measures in the financial services space, is a good example of a public purpose that isn't, it isn't general, it doesn't apply to all areas, but in a particular area, the financial service area, provided that certain criteria are met, reasonable and precautionary measures, then public purpose can legitimize state action and trump the promises that are otherwise made to investors. And we think this special public purpose category idea of a limited area with conditions is very helpful and can be used to develop a standard of public purpose that includes ideas of proportionality and reasonableness. I'm sorry, I'm handicapped here not only by my brain, but by my terrible handwriting. I guess turning to the questions relating to our suggestions, there was a very difficult question on how arbitrators would apply a clear and convincing evidence standard in an effective way. I mean, it's a great point. International investor state arbitrations typically don't even use common law labels for evidence. And I think our idea here, while we would like to have a higher evidentiary standard on a government justifying its actions as being based on public purpose and not on some other doctrine or right, we'd like to have a higher evidentiary standard apply, something akin to our common law standard of clear and convincing evidence. The main idea is that the burden would be on the state to justify its exercise of power under this doctrine, if it's invoking this doctrine, and that the state would have to do so to meet that burden, not merely by a bare preponderance of the evidence, but in some sort of convincing way, in some way that would leave the arbitrators firmly convinced that the state's invocation of this exception to limitations on its power was properly based. There was a very intriguing suggestion about the relationship between public purpose, as we see it in these instruments, and the definition of commercial activity under the Foreign Sovereign Immunities Act. And the Act tells us that commercial activity is to be defined with reference to its nature and not its purpose. Simply because a government intends to do something for a sovereign reason or has a sovereign purpose for its action doesn't make that activity non-commercial under the FSIA. We have to look to the underlying nature of the Act. And that, I think, can be a very helpful idea for looking into the doctrine more. There may be some differences. I mean, the legacy public purpose doctrine really thinks about a government's claimed purpose, its asserted purpose for action. We're acting in the public good. But there may possibly be some actions that would be considered commercial activity. I'm trying to think what they might be, buying, paying for environmental remediation or something that might be commercial activity but might still fit within the public purpose doctrine. We do have the problem that the public purpose doctrine uses the word purpose in its name, and so there's some idea of intentionality or of goal, if not intentionality, behind it. Apologize. The relationship between international investment, the public purpose in the international investment context and the Fifth Amendment jurisprudence is also very interesting. I agree that both areas are not well developed. What underlies them comes from similar but different sources, I think. Both are, in both areas there's this idea that if you're taking someone's property, it shouldn't be for selfish, private reasons. It should only be to further the common good. But because the doctrines have developed from different theoretical bases and in different ways, in different arenas, it may be that they will be divergent. I'm not sure, as wonderful as our Supreme Court is, that I would want to entrust the international public purpose doctrine to their jurisprudence any more than I would to wonderful investor state arbitrators and the counsel who practice before them. Darn it. And I think the final question was the idea between the relationship, the idea about the relationship between a reasonableness test and the Lowenfeld idea of reasonableness in jurisdiction. And reasonableness, I think, is part of what we're looking for in searching for a standard here. Reasonableness, particularly in the context of proportionality, of the measure, the state aim, the state goal, the state purpose in that sense, and the interests encroached upon. So I think there's certainly room for that. One of the things that we're also searching for is predictability of result, objectivity, and reference to standards other than the state's own standards. And some of that works well with reasonableness. Predictability is more of a challenge, and I think it's also an excellent idea for further thought and further work. So to sum up, it's always easy to tear down, hard to build up. We've done a lot of tearing down in the work, and we think that there are many ways in which the doctrine can be furthered, as described in the 11 proposals, but that it will be an incremental process, one that should not be entrusted entirely to arbitrators and counsel, one that unfortunately cannot be entrusted entirely to international multilateral negotiations, and perhaps a step at a time, an actor at a time, we can move towards a more coherent understanding of the doctrine. Thank you.
Thank you very much. So I wonder whether Jack or Harold, you want to comment, and then I open to the floor.
Yeah, I think the more that I listen to what you say, I think that there's a tension between the horizontal and the vertical, and that the horizontal is about interdependent sovereignty between nation states, and then interdependence of relationships between nation states and multinational entities and investors. But I think what may end up being the most important thing in determining public purpose will be this vertical relationship between the state and the citizens. And one of the differences between the Fifth Amendment and international investment law is that when the state asserts a public purpose, whether it's communist China or the United States, they don't look behind it. But in fact, there's a very different democratic value being served. I say this because I just got back from China and Franco is going there. They were telling me the story about how they built a subway and they literally told nobody. There was no consultation, no nothing. People went out on the street one morning and suddenly thousands of people are up, ripping up the road and destroying people's houses to build this subway. And there apparently had been no notice and comment. The simple statement was it's for a public purpose. And just compensation that they're going to pay whatever it is will be close to nothing. Now, I think we think of this quite differently if we think that the people have been heard or the government is asserting a public purpose vertically on behalf of people's democratic values than if we think that they're just acting based on the will of a few who happen to be in charge of governmental power. So it may well be that this hierarchy of public purposes you're describing, which I think is a very important idea, will be at its height when the government is effectuating the rights of citizens. For example, in the cigarette case, the right of citizens to be free of disease. Then the government is really acting as a parens patriae for the democratic values of the people. It'll probably be at its lowest when the government is highly autocratic and is simply asserting something as an interest of the state, but it's actually overriding private interests on both domestic side and on the foreign investor side. And I think that it may well be that there's not the same rule of public purpose for democracies and autocratic governments, and that may end up being something that stands in the way of being a single customary international law rule.
I was very actually impressed. You were a little apologetic by the way you replied to us, but I couldn't have done it so well. Couldn't even answer my own questions, let alone his and mine. So congratulations on that. I think there are a number of just pedestrian kinds of prosaic things that sort of come up the works a little bit, just linguistically speaking. As I said, you say public purpose to me, I associate it immediately with a narrow context of expropriation, and if one were to look it up on a search engine right now, you would find a lot of domestic law references to it about taxing power and other kinds of things, but in international law we tend not to think of it writ large. So that is endemic. As a functional matter, I think another problem, or actually perhaps a solution, as to why it doesn't get more fully examined and more developed is because there are proxies for vindicating the concerns that would otherwise. So a tribunal that is now told in BITs that a taking is not lawful, not only if it's for want of a public purpose, but also not consistent with due process, not consistent with fair and equitable treatment, because they incorporate these other sections into the taking section. And so, there are all these subsidiary things that bear on process and how states come to do what they did. There's also, often under the fair and equitable treatment analysis, a sense of proportionality. And also, some tribunals are willing to look behind it to, as I suggested, almost a substantive due process question of to what extent does the remedy appropriately address and has a basis in something that is justified. So all those things are sort of proxies for part of what you're getting at, I think. And this is why we become less concerned with it. But I take your point completely. You teach expropriation, and you say here are the elements classically understood, and every time I write public policy on the board, I think, okay, what is there to say about this? And I am seriously very interested to see in the last sort of 10 years what tribunals have said, because I know claimants have said this was not done for a public purpose, therefore I want more compensation under Chorzo Factory. And there's a whole issue there of how you interpret the BIT, whether you get what it says and no changes based on illegality. But I'm sure there must be some new sort of thinking on that. But I don't see it coming to any sort of galvanized sense around either hierarchy or what we mean by this until tribunals begin to articulate it, and this inchoate sort of understanding then becomes normative somehow. But we're in an era now where it is, for better or worse, BIT tribunals that are announcing on these things. The interstate level is perhaps helpful, but the other thing, I mean, the interesting question of what function does 114 serve if, and those other provisions that say subject to this agreement. And it's an interesting question. I mean, I defer to my brother here about how what things go into treaties and why they do, but they are, if nothing else, importantly symbolically important, because they say to the reader, we have taken these things on board and we have considered these things. And there's a certain appeasement that goes with this. I know Harold was probably closer to the task force that looked at how we should amend the BIT from the most recent version came was 2012. And when I read the report, there was very little agreement, because the labor people said, well, it should be all about labor, and some people said there should be no taking it all and no investor state, and so just to give a certain level of homage by referring to sustainable development, referring to international labor understanding, I think it serves sort of it's a signaling mechanism for countries that are not associated with those values. And so that sort of gives us something to talk about when we're talking about these countries that are trying to come on board with these ideas. So, but 1114, it's a little deceptive when I just read that part. It also talks about the fact that states should not make a race to the bottom with their environmental regulation in order to attract investment, and to the extent the other state thinks that it has, they should consult. And so there is a interstate kind of secondary paragraph 2 of that tells us a little bit more about 114 than just the part that I quoted.
If I can just add a couple of points. I mean, those were great points. And I think on the issue, going in reverse order, of 1114, it's interesting because it almost highlights the state's obligation to regulate, which is the other part of the public purpose issue that we haven't talked about very much tonight. Claimants in international investment disputes want to talk about the state's obligation to protect investments and maybe the state's qualified right to regulate. But the state does have an obligation to regulate, to protect its citizens. And the part of 1114 that you mentioned, I think, goes directly to that idea. It's there are lots of provisions in the treaty structured like 1114, subject to, so long as there's no violation of this agreement, it won't automatically be a violation of this agreement if we pass an environmental regulation. Well, it may be a signaling mechanism. It may have to have some more normative content, perhaps, if we want to interpret every word as having an enforceable meaning or a legal meaning. But either way, perhaps it's an expression that this is an important idea of the public purpose being protected and carved out under the treaty. It's an interesting problem, and one that I hope to learn more about. The idea of proxies, I think, is very interesting, because as you pointed out, there are proxies for claimant investors to the expropriation doctrine. Even if public purpose doesn't help the claimant in terms of protecting it against expropriations because it's devoid of content, you can also bring a fair and equitable treatment claim or other types of investment claims. But governments also have proxies for their defenses, including the necessity defense, and various other defenses that are available in international investment law. So it's perhaps because of that reason that the governments have ways of protecting their interests that need not be covered by the public purpose doctrine. And because the public purpose idea, at least in cases such as Methanex, has been expanded beyond simply the question of compensation to deciding whether there's even an expropriation at all, that I think it's important to invest some effort in trying to understand and define and develop the doctrine. Turning to the idea of hierarchies, it's very interesting that the type of government should perhaps define or relate to or influence what are proper public purposes. And I think that's absolutely right. When we looked at the Human Rights Conventions, some of the things that we saw were that the focus of each of the conventions was determined by that region's historical development. So the African Charter was very concerned with colonization and decolonization. The European Convention, not so much, not at all, in fact, much less focused on economic rights per se. And there's even the idea I believe it's in the American Charter, that public purpose can qualify some human rights when they're related to democratic values and processes, but not otherwise. And that would, of course, only apply in a country that is pursuing democratic values and processes. So it reminds me of a book I absolutely loved when I was in law school by John Hart Ely, which looked at constitutional interpretation from a standpoint of procedural values. And it may very well be that public purpose includes procedural goals and procedural values, and that finds its way into a hierarchical view of the doctrine.
You know, it occurs to me, I mean, to some extent, this is a system ordered by states. And if you ask yourself, what is the state's interest in bringing greater clarity to public purpose? In a way, the incentive isn't really there because they're not being called on it in the expropriation context or any other. And so I don't see what induces them, absent, you know, perhaps getting a new sort of claims. We're beginning to focus on that, and tribunals taking it seriously. But I mean, think about it. Right now, it's essentially so vague that it's conflated with a state act, right? So how do you energize states to say, well, this matters, I read the book, is part of the problem?
Switch off.
Well, it's a great point, and perhaps this is where international litigation and arbitration can serve a very important role. Yes, the doctrine is currently very strong or very weak, depending on whose perspective you have, but states, because the doctrine is not well-defined and not uniformly accepted in a particular expression, states face risk every time that they have a disagreement with a foreign investor. And the development of objective standards that lend predictability serves both host states and the investors of home states. And while it's true that the host states are, I think, doing just fine right now with the doctrine the way it is, they may have an incentive to pay attention to it in order to achieve greater certainty and predictability.
I would like to open actually to the floor as well. I know that we will see each other later. We can go on. Yes, please, Victor.
Yeah. About 30 years ago, I guess I taught a seminar on takings law, and my memory is a little bit shaky on that, but my impression is that the public purpose doctrine in American law was essentially to divide the world between the compensable, the stuff that you can take and the stuff you can't take. And basically, everything ended up being public purpose. There's almost nothing on the other side. The distinction that did matter was physical takings would be compensated, and non-physical takings, regulatory takings, were basically not compensated. The puzzle I have here is why you seem to think that the regulatory takings are so obviously public purpose and can be routinely compensated. That seems to be the odd thing to me. You mentioned the Fifth Amendment, Harold, and the Fifth Amendment says most of this stuff would clearly not be compensated. And the cigarette thing would be a joke, right? So I just don't understand why it is that in the international regime, the regulatory takings are so routinely considered, seriously compensable.
So my understanding of Fifth Amendment law, and I only dip into it every now and then, is that the physical, non-physical taking distinction started getting debunked by the early 80s, the teleprompter, Loretto versus teleprompter case, where, the question was someone putting a cable wire on your apartment building compensable because there was a physical touching? And people like Frank Michelman in their articles had attacked the notion of physical versus non-physical takings as absurd, and I think it's even more so now that most non-physical takings can, really take as much property without any kind of physical effect. The other, though, I think, is Kelo. I'm from Connecticut, and I think that Kelo is widely viewed as a case where the city of New London took a big chunk of land and just gave it to somebody, which would be a classic violation of public purpose. But I don't think that's what the court saw. And so I think that what they've done is been extraordinarily unresponsive to the concerns of public, of ordinary citizens in how public purpose is determined. And I think that's what I was trying to get at earlier, which is, if the government of China decides to take a huge chunk of land because they want to set up a subway train, and in the process overrides people's concerns about environmental safety or other kinds of things, they've done the balancing in a non-democratic way. And that's quite different from when the public purpose is an expression of a democratic interest, which is what's supposed to happen in a constitutional democracy.
Well, maybe just to follow up, it's a little different in the international context for a couple of reasons. But one is, while a taking that's not for a public purpose may be illegal, as it would be in the U.S., there's no one to stop it from happening. So the taking will still presumably take place. I mean, I suppose an international investor-state tribunal might say to the state, give it back, but as a realistic matter, that's not going to happen. And in fact, most of the treaties don't seem to contemplate that type of relief. So
my point was only that public purpose serves almost no function here in the U.S. determining what is compensable and what is not. Mm-hmm. And it's still true that the regulatory takings are almost always not compensable, whereas the physical ones almost invariably are. So I mean, that is the strong distinction that we do have here. And I'm just, again, puzzled why the international is so different. And where public purpose does no work in the U.S. context.
Well, I think the Supreme Court could best explain why public purpose does almost no work, and Kelo obviously was a hotly debated decision. In the international context, the source of law is a little different. Typically, it's a bilateral investment treaty containing guarantees against expropriation. The language is a little different than the Fifth Amendment's taking clause. And the idea of a regulatory taking is something that's generally accepted. I wouldn't say widely accepted, but generally accepted in the jurisprudence, that government action that reduces all or virtually all of the value of an investment can be tantamount to an expropriation, which is language we often see in a treaty, language tantamount to an expropriation. So even though title is not transferred, there is a wider recognition of regulatory takings than here. But even in the U.S., there's some doctrine allowing for regulatory takings to be compensated under the Fifth Amendment. It's thin, yes.
Yes, please.
My question has a sociological component and a legal component. I'll start with the question, and it is a question because it has a question mark at the end. Do you see any limits on the powers of an arbitral tribunal when it comes to examining public policy issues? And I ask this question because you have competing values. If you look at it from a sociological point of view, statistics time and again confirm that The arbitral tribunal are from the developed world. It's male, pale, and stale. And are we really allowing three people who have probably no understanding of the region to look at South Africa and make determinations on race issues? That is happening, say, in the border timbers case. Or in India, when it comes to matters of corruption. Are we really allowing these three people to make these determinations? The competing value would obviously be the Wimbledon rule that, you have signed a treaty, the treaty says public purpose, and it should mean something. Sociological issues aside, there's a wide spectrum when you talk about the legal standard when it comes to public policy, because you have one end of the spectrum, you have the US restatement and tribunals that sort of conform to that school of thought, where you give a very wide deference to the state. Versus, and I'm going to talk about the ADC v. Hungary case, which I think stands out like an outlier in the jurisprudence. The tribunal really, it didn't do what 99% of the other tribunals do. That is, there's no compensation and that should end the discussion, the expropriation. They actually looked at each requirement and said, Hungary, you have to prove public purpose. You have to show us how European Union law required you to do what you do. And many people would say you placed a very heavy burden on the state. So in the light of this, what do you see as the role for the arbitral tribunal, and do they have any limits?
Maybe I'll start, and others will fill in. I think you've very nicely identified the tension between the competing policies. It is important to point out that arbitral tribunals don't have to be male, pale, and stale and from outside the region, and that respondent states typically are appointing one of the arbitrators and have the option to try to agree on another of the arbitrators. And it's very important to take into consideration when appointing the arbitrator someone who will have sensitivity to the relevant values and customs and policies. That being said, I think in order for this investment arbitration system to work, and more broadly the foreign direct investment system encouraged by bilateral investment treaties and multilateral treaties to work, investors typically don't want to go to national courts. They typically want a tribunal that is removed from those sorts of pressures and that risk of parochialism. They want their investments to be protected under international standards and standards that are generally accepted by as witnessed by the fact that we have something like 3,000 bilateral investment treaties out there. The states have agreed to these standards, and perhaps a real question is, yes, but who should be interpreting them? But the states who've signed these agreements have bought into this system of arbitration. So I think it's appropriate from sort of a legal perspective. It's what the investors certainly would like. We now see some states pulling back from the system because of concerns that it has not been sufficiently respectful of their concerns. But it's still, I think, sort of the gold standard for resolution of disputes between investors and states, and it's going to be hard to move away from, I think. I don't know if there are other comments.
So I think there's the reality that public purpose, if invoked in a bilateral investment treaty setting, will push arbitrators beyond their actual competence if their basic experience is as private international lawyers doing international economic law. Because increasingly these cases are encompassing bigger issues of social policy, including, for example, the right of public health to protect the citizens who are affected by tobacco smoking, or environmental standards or labor standards. I think, though, what is actually happening is it will come into play in the choice of the arbitrator. And that while people speak against the notion that judges from the ICJ should sit on these tribunals, they are actually people who, from their day-to-day work in public international law forums, have broader experience in assessing the scope of public purpose. So I'd be perfectly comfortable to have Bruno Zimmer or individuals of that nature, Steve Schwabel, who have sat on these public international law tribunals making assessments of public purpose, because they're not going to be limited by the scope in the way that someone who has spent their career teaching particular issues of commercial law might do so. So I guess what I'm saying is, if the BIT system and BIT arbitration is going to drive the process of dispute resolution, there's no way around the evaluation happening from public purpose assessments by such arbitrators, but it may well be also that the group of arbitrators will include those who are broader engaged and better able to assess those, and those are the people who ought to sit on the more important and influential and generative cases. We are, by definition, talking about tribunals formed under a BIT or a multilateral instrument, and the method that one sees these days of comparing to models of 20 years ago is a greater detail being added to these BITs. For example, I mentioned Annex B that gives guidance that narrows the scope of what tribunals can do. And so the answer that at least states are adopting tends to be putting it in the BIT so as to circumscribe the mandate of the tribunal in that way. Another example are the interpretive notes that the two states can issue and say, for example, 1105 just means the customary international minimum standard and not what Webster says it means. And so as far as that goes, the more unifying thing occurs when the cross-pollination of BITs. Now, if you compare BITs, the U.S. model looks very much like the Canadian model, and now the Korean model looks very much like the U.S. model, and so on and so forth. If these ideas get replicated, they produce a sort of norm-creating sense of it. And so if Annex B begins to be, in fact, if you look at Methanex, it was decided under NAFTA, but the standard they used was essentially the Annex B standard, sort of prospectively applying it, even though it wasn't found in the text, but treating it almost as custom. So I think the key is to craft the BITs carefully.
I too would think that your sociological assessment is not really true anymore, I have to say. So it's enough to look whom Latin American countries appoint as arbitrator to show that, at least a geographical component plays a role when these countries do identify arbitrators. I'm sitting in 3 cases, and I'm the sole male man in 2 out of the 3. And more so, if you look at statistics, whom will states appoint? We know exactly one name pops up, and it is not a male necessarily. Let's put it this way. So we have time for one more question. Yes.
Hi, thank you for a very interesting and provocative conversation. I guess my question goes back to what I will describe with all due respect as a surprising proposition, or one that I found somewhat frightening, I guess. The idea that the content of a public purpose rule would differ depending on the political system of the state, and that we'd have separate rules for democracies from others. But I want to then retreat from my own shock and surprise, with all due respect to that statement. I guess the question is twofold. I mean, one is really just a request for comment on the notion that the fiction that underlies almost all of international law, certainly international human rights law, and in many international intergovernmental organizations, is that states do represent their people in maybe different forms and not democratically or otherwise, but that's the fiction that underlies the way in which money is lent at the international financial institutions and others, much to the chagrin of many civil society organizations and people who would like to describe it otherwise, and to call into question the assumption that those loans will in fact be used for their benefit. But we nonetheless abide by that fiction. In that context, when the party complaining of the lack of such fiction in reality is an investor, it sounds like we're willing to question it more than we would in other contexts, which I think creates a very troubling, in my mind, double standard. I'm certainly not the first to point out this tension between the way in which investors relate to states in this system and individuals or communities under the human rights regime. But to retreat, I guess, a bit from my surprise, maybe what I would extract from that observation is that are there perhaps procedural questions and standards that parties may invoke, not under the public policy doctrine, but under other provisions of BITS, whether those referring to fair and equitable treatment or other due process hooks within BITS, that wouldn't necessarily empower an arbitral tribunal to sit in review of the substantive purposes that a government purports to pursue. And in that vein, I guess the discussion about the hierarchy of public purpose, or the idea that tribunals would then start to define such a hierarchy, I also find deeply troubling. And just as a final remark, and I guess except for my one question thrown in the middle, it's sort of a comment in eliciting reaction, is just in defense of my colleague's proposition that there is still a sociological issue here. While there may well be an evolution, and I would argue, I agree, a progressive evolution in the composition of arbitral tribunals in recent times, the idea, nonetheless, that you would have three people of whatever gender or origin opining on the legitimacy of the state's purpose in undertaking certain action is nonetheless troubling. So this maybe all goes back to the fundamental question, which I believe Professor Coe posed, about the difference between public action undertaken for public purpose and state action more broadly. But I would love reactions on the differential tolerance for the fiction on which international law is premised in different contexts, and on the procedural avenues to pursue the kinds of claims that are currently being argued under public policy doctrine. Thanks.
Well, I guess as the person whose comments elicited the reaction, maybe I should start. Let me start with the idea that it should be troubling that three people are deciding these cases. And I understand that feeling. It's troubling to many investors. It's troubling to many states. It's an effective way of doing arbitration. And it's important to realize that while these cases have public implications, they're fundamentally resolutions of private disputes, in the sense of disputes between two parties, one of which is a state. They don't purport to set state policy. They're fundamentally about compensation to investors who have allegedly invested pursuant to treaty rights in the state. So it's not a perfect system, but it's not like we're letting three strangers take over the government in that sense. It's important, I think, to consider it within bounds. I should not have implied that democratic states have more rights than non-democratic states. That's not what I was trying to suggest, and that's not what you said, but I want to make it clear that that's not what I was trying to get at. I think the idea is that in the hierarchy of public purpose, there are some process-related values that may be public purpose that apply more clearly to democratic states. And we see this in the human rights conventions that we talked about, where sometimes you can restrict a human right in the service of democratic type interests, at least for the rights that are lower in the category. You can't, we would submit, invoke public purpose simply in terms of actions taken for regime perpetuation or ideological dissemination. Well, those are things that may be state action. They are state action in many places. They are certainly something that the government intends to do. They're the purpose of the government. But we would argue that's not the sort of public purpose that is really contemplated. How should the doctrine be developed in terms of the hierarchy and attention to the type of regime? Perhaps it relates to the evidentiary standards that we were talking about, a regime that is not able to show that it gave much consideration to reaching a decision to take away property, perhaps has a tougher time meeting its burden of proof, or perhaps has more difficulty in the proportionality analysis. That's not to say that we divide governments into groups and say, well, you know, you're an authoritarian dictatorship, you have a higher burden of proof. But in considering whether process has been given, and this goes, I guess, into the last point, there are other avenues for protecting some of these concerns for the investor. There is a denial of justice claim that's typically available. The fair and equitable treatment claim can accommodate some of these concerns. But if we're serious about trying to define what is public purpose as it applies to the legitimacy of an expropriation, or perhaps more broadly, whether regulation amounts to expropriation, it may be fair to include in the hierarchy the idea of procedural values as well as simply government ends in themselves.
So I think the human rights revolution is here, and so we look behind claims of public purpose just like we look behind claims of sovereignty. And claims of sovereignty were used to mask actions by states that ended up destroying the human rights of their own citizens. And it seems to me that there's a big difference between a state action which claims a public purpose when in fact the purpose is the impoverishment of the people. I'm Korean. You know, Kim Jong-un, if he asserts in some public forum that he's acting for a public purpose by impoverishing his own citizens, it seems to me that that's not something that's that you can take a tough look at whether that's really for a public purpose or not. Now then the question is, how do you fit this into what Ryan and Pedro are calling some kind of hierarchy of public purpose? That there are obviously things or steps that are taken as a result of a constitutional effort by a society to protect certain counter-majoritarian values, you know, core human rights values. Secondly, there are those that are designed to protect democratic values as expressed, you know, when someone votes in a referendum. So if a lot of people are voting in favor of laws that protect their public health against tobacco smoking, the government is really doing a kind of bottom-up expression of public purpose. So I think it's entirely possible that we'll get to a situation where top-down expressions of public purpose by authoritarian figures are just given less deference than bottom-up expressions. And the ones given the least deference will be those which are expressions of public purpose that are violations of Jus Cogens norms. And then that will be a melding of human rights law into investment arbitration law. Now then the question becomes, who are these arbitrators? They have to be people who are capable of evaluating these kinds of issues. And if you listen to somebody like Giorgio Gaia, his comment would be that in fact the International Court of Justice is increasingly becoming a human rights court, and the judges who sit there increasingly are hearing human rights arguments parading as sovereignty arguments. And I think that if those individuals also sit as arbitrators, they will be taking those same values. You know, a guy like Trinidade Cansado is very much a human rights person sitting on a public international law court. I don't know if he does much in terms of investment arbitrations, but he would be approaching it from essentially this perspective.
Thanks a lot. The purpose of today's session was to offer to the public comments on a book on public purpose. I think we reached that goal. Thanks, of course, to the commentators, to the co-author for commenting on those remarks. The very last forum of this academic year will take place on April 27th. It is on theory of international commercial arbitration. I hope to see you there. Thanks for the comments, thanks for the patience, and see you soon.